Welcome. My name is Charlie Bailey. I'm a solo practitioner with an office in Decatur, Georgia. I've been practicing exclusively in the area of family law since 2001. And beginning in 2010, I began devoting my practice entirely to alternative dispute resolution, serving either as a mediator or as an arbitrator, and then also in providing services as a guardian ad litem. I've been asked today just to speak for a little bit about my experience as a guardian ad litem and my approach to those cases, and I'm happy to do so and honored to have been asked to do so. In that regard, let me say first of all, and this may be obvious, if you're a party in a case and you've had a guardian appointed, or if you're an attorney and you've had that guardian appointed that you haven't worked with before, always take the time to ask that guardian at the beginning to sit down with you and explain his or her perspective, their approach that they plan to take, how they see the case unfolding or their investigation unfolding. What I can share with you is my experience and how I tend to approach my cases as a guardian. But every guardian is a little different. Some of us may have very different approaches, but even though there's some consistencies among most of our work, each of us, I think, has a little bit of a different tack or a different perspective on it. In the same way, if you were going to do a trial, certainly you'd want to have some more information about your particular judge and how he or she views the issue of custody. What I do typically in my guardian cases is once I have been appointed, I will send out a general informational questionnaire to each of the parties. And once I have that back, I will then schedule a time for me to sit down with each party individually. The purpose of that meeting is very much like this informational video. It is for me to provide them an overview of my perspective and my approach, and also to give them an opportunity to ask any questions that they may have about the investigation process or the role of the guardian ad litem. I usually begin by taking the time to explain that first and foremost, I'm not the judge. I don't have any authority in the case to compel any resolution or to make anybody do anything. I can make recommendations. As I go along through the investigation, I might make temporary recommendations. I may not. I may wait until the very end, and I may not make a recommendation at all until the case is either ready for mediation or for trial. But at any point, when I do make a recommendation, it is just that. The parties are free to adopt anything that I might recommend as we go along on a temporary basis. When we get to trial, obviously, it is the court, the judge, and the superior court who will ultimately make any decisions about custody. So while my role may be influential to the judge, I'm not the one ultimately making those decisions. The way I describe my role primarily is that of an investigator. My job is to do, in effect, what the judge cannot do for a variety of reasons, including different rules of evidence. The judge cannot, for example, call and talk to the parties on the phone, cannot go to the party's house to meet with the parties individually or to talk to the children. The judge can't go to the school and meet with the school teachers, or just pick up the phone to call the family therapist or perhaps the child's therapist. The guardian ad litem laws in the state of Georgia allow us to do that, and allow us then to be able to provide information within the rules of law, the rules of evidence, so that the court has as much information as possible when making a decision. Our system, for better or for worse, has custody decisions being made in the judicial system in a legal context, even though custody itself really isn't a legal issue. Certainly the question of who has authority and who has the right, if you will, to have care and custody of a child, those can be thought of in legal terms. But when we talk more broadly about child rearing, what is the best way to raise a child who is happy and healthy and well-adjusted? Those typically are not topics that we think of as being discussed in the legal field, but more perhaps in psychology, sociology, human development, maybe even philosophy. Nonetheless, we're making these decisions in the context of litigation. And so, again, it's important to understand where the guardian is coming from, just as it's important to understand where the judge is coming from. Uniform Superior Court Rule 24.9 defines the guardian's role as being to represent the interests of the children. It goes on to say that we serve as an officer of the court, and that our role is to assist both the court and the parties in reaching a decision about custody, visitation, and then it says child-related issues. I mention that because there's a lot of guardians, myself included, that tend to stay away from anything related to finances. And as a general rule, I think that's appropriate. There are, however, occasions where a specific issue of finances may fall into that category of another child-related issue. Similarly, as a guardian, I tend not to make specific recommendations about activities for children. But again, that may be a child-related activity that, depending on the particular case, may need to be addressed. I'll give you an example. If there is a child who has special needs and who has been particularly involved over time with a particular therapeutic activity, it may be important from my perspective as the guardian that the child be allowed to continue in that, even though the parties may disagree. One party may be in favor of it, the other party may not be. But for the sake of the child's best interests, it may be important in my mind that he or she at least continue with that activity, notwithstanding any other activities that may be added or taken away. So that might be an example where I would make a specific recommendation. Similarly, I tend not to make any recommendations with regard to child support. I don't believe I've ever made a recommendation on direct child support, certainly in terms of the amount of the child support payment that should be made every month. I have on occasion, though, weighed in on the issue of specific obligations for specific expenses. Again, another example would be a case in which the two children in the case had always been very active and involved in their church group, and they attended every summer a church mission trip. These were older children, they were both teenagers. This is something that they've been doing for several years, and it was a highlight of the year. Both children agreed that that was something that was important to them and that they wanted to be able to continue to do going forward. The problem was that the parties, although they didn't disagree about the children participating in that activity, they did disagree about who should have to pay for it. And so my recommendation included a specific division of those expenses, because it was a way of taking that off of the table so that neither party could say, well, I'd love for you to do that activity, but your mother won't pay for it, or your father won't pay for it. By making that recommendation to the court and having that specific recommendation included in regard to payment of that activity, I was able to take off the table a source of conflict between the parties. Generally, though, as I said, the guardian is going to be focused on questions of custody, legal custody and physical custody. The Superior Court rule uses the word visitation. Most of us, I think, today use the term parenting time. And then, as I said, other child-related issues. As I said, my role primarily is that of an investigator. What I will do over the course of my investigation is talk to individuals, review records. I will gather information that at some point, if the case goes before the judge, I will then provide to the court in the same way that an investigator would present other information to a finder of fact. Again, my job is not to make a decision. The caveat to that is that the Superior Court rule does say that the guardian is supposed to make a recommendation to the court. Here again, it's important to know your judge as much as anything. Some judges are very consistent in terms of following the recommendation of the guardian. Other judges tend to be very clear that while they will consider what the guardian has to say, they're ultimately going to make their own decision. And that, in fact, is how it ought to be. That's the judge's role. Although I do serve as an investigator, and in some ways, I'm there simply to provide or to present to the court the information that I have gleaned from my investigation. Superior Court rule also says that I'm to represent the interests of the children. And in representing, whether it's a party or the interest of the children in the case of a guardian, that does entail a certain degree of advocacy. A lot of times people will talk about a guardian as being neutral and unbiased. First of all, as we know, we all come with various biases to any particular case. The significance there, the important thing there is for any guardian to understand his or her biases and how they may affect a particular investigation. The question of neutrality, though, is a different question. I certainly am neutral when I begin my investigation. I do not come into any case with some preconceived notion about either parent being a better parent, nor do I even approach a case with any preconceived notion about whether primary physical custody is better than a true joint 50-50 custodial arrangement. I try very hard to be as neutral as possible when I go into the beginning of the case. As the case develops, though, and certainly as I begin to formulate my own recommendations for the court, I do become more of an advocate. I have a sense, I have an opinion of what I believe is going to be in the best interest of these children. And it's my role as a guardian to present that and to advocate for that. Now, one of the things I tell parties at the very beginning, and I tell the court this often when I'm on the stand as well, I don't have a crystal ball. I cannot say that my recommendation is right and that somebody who disagrees with me is wrong. My hope is, whether it's consistent with my recommendation or not, is that the judge will get the right decision. But none of us know the future. None of us know for sure what's going to work and what's not going to work for a child. And so all I can do is present what I have come to conclude to be in the best interest of the child based on my experience and based on what I've been able to glean from my investigation. It does not necessarily reflect a judgment about either of the parties. I am simply advocating for what I believe to be, in the long term, in the best interest of the children. The other thing I like to point out is that very often there's not just one answer. There are multiple ways and approaches to raising children. Very often the conflict that we see between parties is really just a conflict or a difference in parenting styles. And although parents like to see them as being as one as being better than the other, more often than not they're just different styles, and neither one is necessarily better than the other. What that means then is, when I go to make a recommendation in a case, I have to consider two things. First of all, are the parties going to go into this parenting plan by agreement, or is it going to be a parenting plan that is imposed, if you will, by the court? So it's not uncommon at the end of my investigation, or as I'm going through my investigation, I'm formulating a recommendation. That recommendation may change. It changes for a variety of reasons. One is that the longer the investigation goes on, the more information I have. The more information I have, that may affect how I view a certain issue, or how I view the parties' relative parenting skills and co-parenting skills. At the same time, my recommendation may vary simply on whether or not it is a recommendation being made at mediation, or whether it's a recommendation being made at trial. And in mediation, the parties, if an agreement is reached, are going to agree to it mutually. Neither one of them may particularly like it. One of them may like it more than the other. But there is at least some investment on both of the parties' parts. They're both buying into it on some level because they're agreeing to it. That kind of a parenting plan is more likely to be successful than a parenting plan that is going to be imposed on the parties. If the court, on the other hand, at trial, imposes a parenting plan, one or both parties is not likely to be happy with it. And you have a much greater likelihood of ongoing conflict between the parties in that scenario. So often what will happen is I may make a recommendation at mediation that I think will work because it, by definition, would include the buy-in or the investment, if you will, of both parties. That recommendation may change at trial, though, where I know at the end of the day, the judge is going to make a decision and one of the parties is not particularly going to like it, but they're both going to have to live with it, regardless of how they feel. One of the things I like to tell people at the beginning is that when I begin my investigation, there's no way of knowing, there's no way of predicting how long an investigation may last. I encourage people to tell me on the front end during that initial visit, what do they think the major issues are? What do they think ought to be the focus of my investigation? I will listen to that, and I will certainly address and look into any issues that the parties raise or that their attorneys raise. But I may look into other issues as well. But one of the things that I want to caution people against is that if you don't raise an issue, and it doesn't become apparent, or it isn't something that's going to become apparent just to a typical sort of outsider looking in, you have to raise those issues. I've been involved in cases where at trial, one of the attorneys on cross-examination, would ask, yes, but you didn't look at this issue. You didn't look at this issue. You didn't ask the attending physician about this particular medical concern. And my response to that is, well, I didn't because I didn't know about it. Nobody's raised that issue. Nobody ever told me that that was a concern before. That's not a particularly effective way, I don't think, of litigating a case. It also hand-ties the guardian. I can't be expected to do a meaningful or an effective evaluation if I don't know what the issues are. So I tell people from the beginning, tell me what your concerns are, and I'll investigate those concerns. As the case goes on, if additional concerns are raised, I'll look into those as appropriate. I will also investigate issues that I think are relevant, perhaps that the parties haven't looked at. That certainly, again, is within my prerogative as the guardian. But I need the parties and their attorneys to talk to me. I need them to communicate with me and tell me what they see as being important. Even if I don't necessarily agree that that becomes an important issue, it's an important data point to have. It tells me where the parents are coming from, or at least where that particular, perhaps, attorney may be coming from. As part of my investigation, as I mentioned, I always meet with the parties first. Once I've met with both of the parties, I will then schedule a time to meet with the children. How often I meet with the children, the frequency, the number of times, what I do during those visits, it depends. It depends on every case, it depends on each child, it depends with each family. Younger children and older children obviously are very different. My interactions will be different. It is a rare case where I might ask a child directly about his or her thoughts on a parenting plan. That almost only ever happens when you have teenagers who have executed affidavits of election. And in that instance, I'm going to explore the issue of how those affidavits came into being, how the child first learned of the option of creating an affidavit, who prepared the affidavit, what they talked about with that person prior to doing so. In that instance, it's appropriate to do so. But even if a child is of legal age to execute an affidavit and to make an election of custody, I'm typically not going to ask them directly about what they want. Because again, my role is not to advocate for the child's wishes. My job is to advocate for what's in the interest of that child. The other thing I will do is that I will, after meeting with the parents and after meeting with the child, is I'll then begin to reach out to collateral witnesses, some of whom are fairly common, and I'll reach out to in almost every case. School teachers can be particularly helpful because they spend so much time with the child, and they can talk about whether the child is struggling not just academically, but socially, in terms of their peer relations, and in terms of their development. One of the concerns that I always want to look for early in a case is whether anybody, whether it's the parents or otherwise, have any developmental concerns of the children that are not going addressed, or any health concerns that are not going addressed. In that regard, medical records can sometimes be helpful. I don't necessarily believe, though, that it's important to review exhaustively every medical record, every dental record, every educational record of every child in every case. If the parties both agree that the child is doing well, and a cursory review of the child's records indicate at school that he or she has a good solid grade point average, they're active in school, they're involved in various activities, then it's really not important or a good use of resources to spend a lot of time digging too deep into that area. I'm going to focus my time and the parties' resources on those areas that are most likely to raise questions that are relevant to the case at bar. So I'll meet with the parties, I meet with the children, I begin to reach out to collateral witnesses. One of the things I ask in my original questionnaire that I send out to parties is for them to identify certain individuals that they believe will have relevant information that will be helpful to me and ultimately to the court in making a decision about custody in the case. I caution people not to just list character references. I caution them not to just list family members. My assumption, as a general rule, is that your brother is going to say good things about you, that your mother is going to say good things about you. What I want to know is who can I talk to who has actually seen you interact with the children. Family friends who vacation with you can sometimes be particularly helpful. A neighbor who has children of the same age, or with whom you're scheduling play dates between the children, that can often be particularly helpful. A therapist can be particularly helpful. Some families have nannies or child care helpers, if you will, that are in the home, and they can be particularly helpful. I will reach out to these individuals as a general rule as the case goes on when I think it's most appropriate to do so. What is sometimes, I think, misunderstood, and I try to tell people ahead of time so they don't get confused about it, because that questionnaire is one of the first things they do, I think a lot of people assume that calling those witnesses is going to be one of the first things I do. In fact, it's often one of the last things I do. Excuse me, and the reason for that is simply this. I want to get as much information as I can to be able, if I'm going to make a recommendation to the court, to present that to the judge at that time. If I call a witness at the beginning of a case, and 6 months go by or 9 months go by before the case is going to trial, I may need to then call that person back again to get some updated information, because a lot can change in 6 months or in 9 months. If I wait till the end, then that person has the benefit of all that time to not only talk about what the parties and the children were like at the time perhaps of the initial separation, but also how things have changed, how the relationship may have changed, or how that person's approach or disposition may have changed over the course of the litigation. I am cognizant, obviously, of the fact, though, that when you're looking at specific issues, if there's a witness, for example, who is identified because he or she has specific knowledge of an incident between the parties, there may be some time considerations there. It may be important to reach out to people in a timely manner to capture the best knowledge about a certain event or their memory of something that happened. But if it's generally just a witness who's going to talk in general about the nature of the relationship between the parent and the child, the parent's involvement with the child over time, those are often witnesses that I will wait and call later in the process. At some point after I've had a chance to review records, whether they're school records or medical records, after I've met with the family, after I've talked to various collateral witnesses, I will reach a point where I will advise the attorneys that I'm in a position to make a preliminary recommendation. My preliminary recommendations, or a recommendation for the purposes of mediation, tend to be, and again, this is my approach to guardian work, they tend to be a little more general than what I would ultimately recommend if I was going to have to write a report for the court. And I do that for a very particular reason. If we're going to enter a mediation, I want the parties to retain as much ability to determine the outcome of the case as they can. If I make a specific recommendation on custody prior to mediation and one of the parties likes it, he or she is likely to sort of dig their heels in and say, well, that's what I want, and I have no reason to agree to anything else because I know the guardian has already said that that's what he's going to recommend, and then the mediation doesn't really go very far. Again, I want parties to be able to self-direct, to make their own determination about what's best for their families. Notwithstanding what the Superior Court rules say about the guardian being an expert witness on the child, I believe fundamentally that the parents of the children are the experts on that child. I believe parents ought to be making these decisions as much as possible. And so in a mediation context, I may give a general recommendation such as, I think the parties need to have a custody arrangement that allows for substantially equal time, parenting time, between the children and each parent. Rather than specifying, I think it ought to be a week-on, week-off schedule, or I think it ought to be a 2-2-5 schedule, or whatever the recommendation may be. Again, I want to give some general parameters of what I think is going to work best for the family, but allow the parties then to work out the details of those recommendations. In contrast, if the mediation is unsuccessful, if a trial is necessary, when I make my recommendation to the court, it is just the opposite. It is a very specific recommendation. The Superior Court rules, it talks about writing a report, and it says in there that the guardian is going to provide a detailed findings and recommendations to the court. It then, in the next subsection, says, though, that we summarize our investigation. And this, again, is something that's very different among different guardians. When I write my report to the judge, I always make a list of everybody that I've spoken to. I make a list of all the documents that I have reviewed. If I've reviewed audios or videotapes, I will certainly identify all of those as well. I detail the sources of my investigation. But I summarize what I have learned from those various sources. There are a number of guardians who will identify each witness, and next to each witness's name they will say, I spoke to this person and here's what I learned from this person. I do not do that. Again, I don't know if there's a right or a wrong way of doing it. My particular philosophy, or the reason I don't do that, is very often the people that I'm communicating with are people who are going to be involved in these children's lives for a long time. Whether they're school teachers, whether they're extended family members, they may be ministers of a church or a particular faith community. They may just be the next door neighbor. I'm trying to avoid conflict. I'm trying to avoid burning bridges. I don't want to put the next door neighbor in a position where he or she says something that then gets back to one of the parties, and it necessarily destroys the ability of those parties in that neighborhood to work together for the benefit of the child going forward. So I generally will say, here is a detailed list of everybody I've talked to. Here's a detailed list of of all the documents that I've reviewed. But then I summarize what I have learned from those different sources. What I often do is I will go through the statutory factors that are laid out in OCGA 1993. Sometimes I will do it subsection by subsection. Sometimes I will just try to sort of hit generally on them in terms of categories. But again, what I'm trying to do is summarize for the court so that the judge understands not only what my recommendation is, but the basis for that recommendation. I have had different judges at different times who have a lot of questions about my recommendation as soon as I take the stand. They obviously have read it. They've obviously taken the time to raise questions and to be prepared to ask them. I've had judges who have said to the attorneys, I've read the recommendation, I understand the recommendation, so if you have something specific you want to ask about, that's fine, but let's not waste time having the guardian go through his recommendations and the basis for them. That's ideal. If I've written my recommendation correctly, that's what the judge ought to be able to do. My role as a witness then ought to be simply to answer specific questions or to clarify any questions that may have arisen for the parties or for the judge. If I'm having to testify, though, to explain what my recommendation is, or if I'm having to testify to explain the basis, the fundamental basis for that recommendation, then I think I've failed in my report and recommendation. I'm there to assist the judge, not to add work to it, and certainly not to add time to a trial. I mentioned the OCGA factors. One of the misconceptions that a lot of parties have, and some attorneys do as well, is that they believe that the factors that are laid out in OCGA 1993 constitute factors that the court is required to consider. That statutory provision specifically says that the court may consider any factor that it deems relevant, and then it says including but not limited to, and it lays out those factors. I mention that for a couple of different reasons. First of all, those are not the only factors to be considered. And in fact, there are some of those factors that are not relevant in every particular case. Again, every case is going to be different, every family is going to be different, every child is going to be different. So it's important that we not look at that statutory provision and assume that it provides a specific sort of mathematical formula or algorithm for how custody is going to be decided. The other reason why I mention that often to parties in my initial meeting with them is because there tends to be a misconception that if you go through those provisions and you sort of identify for each factor which parent is best able to meet the needs identified in this factor. A lot of people have the idea that at the end of that analysis then, you simply go through and you count up how many of those factors can dad best meet, how many of these factors can mom best meet. And the party that has the most checks next to their name is the party that wins primary custody. I've been amazed at how many attorneys seem to have that perspective. These are not, in and of themselves, litmus tests. These factors, again, they're not exclusive. Each one has to be considered in the context of each case. They're not independent factors either. They're relative and they're relational. Each of those factors relates to the other. And each of the factors has to be given a varying amount of weight depending upon the facts and circumstances of that family and the conflict or the relationship or the dynamics of that family. One of the things that as a guardian I think it's important to look at and to investigate is not only the individual parenting skills of the parties, but the co-parenting skills of the parties. This gets into the question of minimizing conflict. One of the things that most professionals, most child professionals, child development professionals, and family law professionals would all agree upon is that children fare best in divorce situations where the conflict between the parties is minimized. It does not mean that there is no conflict. Conflict is inevitable. But it does mean that we try to reduce the exposure of the children or the nature of that conflict. Co-parenting is directly related to that. A parent may have excellent individual parenting skills, and one-on-one with the children may be an excellent custodial parent. But if he or she is unable to avoid conflict, if he or she is unable to resolve conflict with an ex-spouse, that's going to compromise that person's ability to be a co-parent and to share custody in a particular family. And so again, we have to look not just at these factors as individual factors, not just as they relate to parenting and the dynamics between the child and the parent, but specifically with how they impact co-parenting skills and abilities. In this regard too, one of the things that I always try and explain to people, and this is easier said than done, and I recognize that, is to keep the eye on the ball. Keep your focus on what matters most at the end of the day, which is not the amount of time an individual has with the child in terms of how many nights the child spends with one parent or the other, but the quality of the relationship and the impact that a parent is able to have on that child's development. That's what matters the most in parenting. And I understand if you're a non-custodial parent,